Okay. Senator, if you'll take front row there.
Take your time.
We'll turn on all the microphones for you. Okay. What bill is it you got? Let's see. I think we're looking at Senate Bill 416. Am I correct?
Yes, sir.
Do you have anybody in the Senate who knows how to tell time? Is there anybody over there who knows how to tell?
I'm not sure, Mr. Chairman.
We thought we trained you better.
But I just want the committee members to know what a delight it is for me to be here this morning. Are you ready?
Well, Senator, the floor is yours.
Thank you, Mr. Chairman, members of the committee. I bring before you today Senate Bill 416. This is a very simple bill. The National Council of Prescription Drug Plans comes up with best practices, if you will, of how to submit certain information. As many of you are familiar, electronic transmission of prescriptions is really something that has really taken off in pharmacy and in medicine, and we're seeing more and more of that. Some of you may have experienced in your own lives what we call prior authorization. Insurance companies don't always cover certain prescriptions, but if your physician can prove that you failed on certain other medications, then you can get them approved by the insurance company. And it's a process we call prior authorization. And what this bill simply says is that when NCPDP comes up with their best practices standards and with the formula for which to follow, that the insurance companies within 24 months, and I've got a committee sub coming here that will change that, and I apologize I don't have it, but we just sent over there to get it.
Your current legislation has 12 months.
It does, but we've been informed and notified that it would probably take at least 18 to 24 months to get this implemented. So out of an abundance of caution, we agreed to take this to 24 months. And simply what it would say is within 24 months the insurance companies would adhere to this practice. And I think everybody's on board with it. I don't know that there's any opposition to it.
Okay. Anyone have any questions for the senator? Oh, 24.
Thank you,
Identify yourself to him. He may not know you.
Thank you, Mr. Chairman.
Well, in a minute.
Okay. Thank you, Senator. I'm Darlene Taylor, District 173.
Yes, ma'am.
I just had a couple questions. Line 16, I want to make sure I'm understanding. Who is going to get this pre-authorization? Is this requiring the doctor to go online and get an electronic okay, much like I just want to make sure. Are we putting this on a doctor to do this?
Well, it has to be the doctor. A pharmacist can't get a prior authorization, only a physician, because in most cases a physician has to justify that other medications that are covered either in Tier 1, Tier 2, or whatever in the insurance have been tried and that the patient has failed on those medications.
How is it being done today? My understanding is it is being done today. It's just not electronic.
That's exactly right. It is being done, and it's a very laborious process and a very time-consuming process for the physicians and for their office staff. And, of course, if we can get it done electronically, this will speed up the process and certainly save the physicians time and money as well.
Okay. How will it affect a small practice that perhaps doesn't have online? And, you know, I have a rural area, and all my docs don't have everything electronic. They may not have the ability to go online to do these things.
Right.
Can they do their part manually and go through the system, and the pharmaceutical will let you know electronically?
Yes, ma'am. That's correct.
Okay.
They'll just continue to do it the way it's done now.
Okay.
Either through faxes or telephone calls or whatever.
It really won't hamper them.
No, ma'am.
Thank you.
Now, you mentioned faxes. Doesn't this legislation do away with faxes?
It will do away. Well, doesn't do away with them, but it just sets the standard for which electronically they will follow.
Okay. Anyone else have a question? Okay. Well, I guess it's time for a motion of some sort.
Do we want to pass this committee substitute, change it to 12, or do we want to go ahead and substitute that here and change that 12 to 24 in those two places? So we'll have it.
Yeah, I think we need to go ahead and do the change it to 24 versus 12.
That'd be on line 20 and 27, I think, some of the two places.
And what we'll do, the substitute will have it, is that it? Okay. 24 and 27, yeah. The substitute, as it goes on its path to rules and all, will have that change in it. Do I hear an amendment, a motion for that change?
I'm ready to change to 24 months in those two places.
Okay, second. All in favor say aye. All opposed, like sign. Okay, now it's time to vote on the bill. Senate Bill 416. Do I hear a motion? I move to pass, and second. All in favor say aye. All opposed, like sign. Thank you, Senator.
Thank you, Mr. Chairman. Thank you, members of the committee.
Yeah, that'd be a do pass as committee, as amended, or as a committee substitute. We'll have to get the exact wording on that. Probably as amended now, since we don't have the substitute. Representative Golick, you were correct. Senator Schaefer dislikes 8 o'clock meetings more than you do.
I would request the chair allow Jay Florence of the insurance department to go ahead and take the stand, as it were, to go ahead and speak to 385 and until Senator Schaefer gets here, and then between the two of us, I think we should be able to, really more so Mr. Florence, walk the committee through the bill.
That sounds fine.
Thank you, sir.
Mr. Florence.
Thank you, Mr. Chairman. Senate Bill 385 is a department bill. It has 3 primary components. The first is relatively simple. It's a clarification of the definition of confidentiality. What it specifies is that the department can keep not only the records that it obtains in the process of examinations, but also the analysis that goes along with those confidential. The second provision is an amendment to a fix from last year's House Bill 413 dealing with surplus line brokers and non-admitted insurance companies. And essentially what that provision does is remove the requirement that surplus line brokers allocate where taxes, what risk taxes are covering. It's really a matter of simplicity. The last year's House Bill 413 was a response to the non-admitted and Reinsurance Reform Act of 2010, which was a federal law, and basically it changed the requirements, and that surplus line brokers previously had to pay taxes based on where the risks were located. But after that bill, the surplus line brokers had to pay taxes based on to the home state of the insured. And so what that bill did, House Bill 413, was allowed the governor to enter into a compact which would require surplus line brokers to allocate where taxes were coming from. And then in the event that we receive taxes, say, from South Carolina, then we would then share those taxes with South Carolina, and South Carolina would do the same thing for us if they entered into the same compact. However, those compacts hadn't worked out, and the governor has not entered into a compact. So as a result, we're removing that allocation requirement. And so that's essentially what the second provision does. The third provision deals with credit for reinsurance laws, and it essentially adds a new class of certified, a new class called a certified reinsurer, which would allow non-U.S. based reinsurers to operate in Georgia more competitively than they currently do, and would allow insurers that cede risk to those reinsurers to receive credit on their financial statements. So, in a nutshell, poorly done. I think that is the That is what the bill does. And
Where does the amendment come? Because this is a committee substitute.
yes, and I have not seen the committee substitute, but I would like to take a look at it. Senator Schaefer was working on that. The amendment is in section 6, lines 465 through 468. And what that amendment would do was essentially allow insurance companies for auto insurance policies to it would eliminate the problem associated with right now when after non-payment has occurred, an insurance company sends out a notice of cancellation, and then that cancellation is not effective for 10 days. And so what this would do is allow the companies to send out a notice of cancellation along with the bill, so that in the event of non-payment, the insurance companies aren't providing 10 days of free insurance, essentially.
So what we're looking at, somebody's not getting 10 days of free insurance, right?
That's right.
Okay. Representative Golick.
Thank you, Mr. Chairman. I just want to make it clear a question had arisen yesterday, and I've seen this language for the first time as well, but I just want to make sure it's clear that on line 466, and this really goes to the issue of, companies have various mailing processes, and a lot of times they're a lot more complex than people realize, because a lot of times companies, in order to be compliant, they have to go ahead and be able to proof of mailing. Of course, we have our statutes. There are 30 days notice on some things, 45 days on others, 10 days on others. So they have to, it's a fairly intricate system, so that if examination were to occur, and it does occur, of course, as regulated entities, later on down the line, they have to be able to prove that they mailed a certain thing at a certain time. So as opposed to this language mandating that a company, shall take a particular path or a particular process with regard to folks who pay monthly and who don't pay their premiums, this is voluntary. It may be included. So those companies who may have more of a customer base that pay on a monthly basis or not, they can go ahead and adopt that process if that fits, their particular billing rubric or whatever you want to call it. But I just want to make sure that was clear. That was not a mandate on our business community, but it was strictly voluntary.
Okay. Mr. Maxwell.
That was basically where I was going with my question, because I know different companies do them different ways. But this still, if this is the only cancellation notice going out, is it still going to be required to be like on the PORS list, the list that can go back and verify that something was mailed to the customer?
Yes, Mr. Chairman. That aspect of it would change.
Okay. I've got a question back on the credit. You was talking about the third thing that was changing in here. Can you go over and give me a little bit more detail on that?
Yeah.
That's a lot of information for us to just pass over with.
Yeah, absolutely.
We're just giving a credit to insurance companies that are.
Yeah. So credit.
All you said there.
Yeah. So credit for reinsurance laws essentially allow for when a reinsurance company, when an insurer cedes risk to a reinsurer, credit for reinsurance laws allow that ceding company to receive credit for the risk that's ceded on their financial statements. Does that make sense?
No.
So
no. Where are you at on the? Was that section 5?
that begins.
I can't even find a section now. I got to get in here and look at it.
Yes, sir. It begins in section 5.
Yeah, section 5 is where I got off track here. I went in the ditch after page 3. So try to drive me out of the ditch on this, will you?
Yes, sir. I guess generally credit for reinsurance laws address situations in which an insurer can get credit on their financial statements for risk that is ceded to a reinsurer.
Okay, I understand.
And what this would do is especially currently non-U.S. based reinsurers that want to operate in Georgia, if the insurer is going to get credit for the risk that is ceded to those reinsurers, then those non-U.S. based reinsurers have to post a certain amount of collateral that is greater than a U.S. based reinsurer would have to do. They have to post 100% of the projected losses on the risk that they're assuming. And so what this would do is create a situation in which the department could look at the jurisdictions where these reinsurers are located, determine certain things, whether look at the jurisdictions where those reinsurance companies are located, and then secondly, evaluate the solvency of those reinsurers.
Okay, jurisdictions being their country of origin?
That is correct.
Or, okay,
Yeah.
not where they were doing business in the United States, but the country of origin, something like that.
That is
Okay.
correct. And then secondly, we would look at the underlying solvency of the reinsurer, and that would allow us to make a determination about what level of collateral those reinsurers would be required to
And
post.
it can be adjusted up or down based on whatever y'all find then.
Essentially, there's more to it than that, but essentially, yes, sir.
More to it than that, I'm scared.
You want to explain the more to it?
Sure. So there's a model rate. This is an NAIC model law that was promulgated that the NAIC came up with in November of 2011, and they also came up with some model regulations. And those model regulations would allow, which we intend to adopt, would require that these reinsurers receive credit ratings from one of a list of large credit rating agencies, and depending on that credit rating, that will help determine what level of collateral the commissioner will require.
Thank you, sir.
Representative Golick, you want to respond to that?
It's a question and a little bit of a comment as well. I know an issue has arisen as it relates to the scenario of what if you have a foreign reinsurer that's been certified or is in the certification process, and a lot of this has to do with the procedural dynamics. Here's the concern. If you've got a foreign reinsurer who fails to live up to their putting up their collateral requirements, you could have a domestic that thinks it's taking a credit based on what they've ceded to the foreign reinsurer, and then all of a sudden, and I know it's not all of a sudden, it's a long process, but then all of a sudden that foreign reinsurer fails to live up to its collateral requirements. The only concern I would express, and I mean it's certainly not a problem with the bill, and is that if and when the department promulgates a regulation on this at some point in the future, it's just a simple request to go ahead and just keep that in mind, so that if one or more of our domestics, like Cotton States or Georgia Farm Bureau or whoever, ends up doing business at some point with one of these foreign reinsurers who purports to go ahead and put up the necessary collateral as required by the commissioner and fails to do so, I wouldn't want to see them penalized in terms of their credits because of the foreign reinsurer's inability to meet their requirements pursuant to the statute and to the reg. And I would ask you just to keep that in mind going forward, just under the category of this could happen, so let's go ahead and make sure that's taken care of in the event it could happen.
Very good. We will.
Thank you.
Ms. Hughley.
Mr. Chair, Mr. Maxwell was asking my question.
Okay, thank you. Ms. Taylor?
Thank you. I was going to follow up on that, but I think he did clear it up. But I do have a question on Section 1. When you're discussing the disclosure, are you discussing only reinsurers, or is this all carriers or folks that file for disclosure information? Is this just to the reinsurers?
The confidentiality portion is not applicable just to reinsurers. No.
Okay, so this would be anybody that files anything with the commissioner's office.
This is related to examinations,
Okay.
And so as we're examining a company, then this clarifies what information the department can deem confidential. So
Okay, I wanted to check on that. Thank you.
Senator, you may want to go ahead and come up to the microphone. We're on 385 now, so. Okay. I think we've already discussed your bill and ready to vote on it, and
Then I certainly don't want to distract you from doing that. But I apologize for being late. I was helping Representative Dollar get here. He was running.
Oh, you have? Well, if you got him here by 8:30, you did a good job.
But it sounds like Jay Florence explained the bill to you. This is simply the insurance department's annual housekeeping bill, and I would urge your favorable consideration. We'd be happy to answer any questions.
Okay. Does anyone have a question for the senator?
Unless he wants to go back and explain Section 5 in a little more detail than what Jay did.
Well,
I was just kidding.
Okay.
Okay.
I don't see any other questions. Okay. All right. A question or? Okay.
Mr. Chairman, could I ask a question? Y'all are working off the substitute, is that
Yes,
correct?
sir.
Thank you.
We're working off the substitute. We have someone who wants to speak on the bill first. Normally we don't do this, but since we didn't go through the subcommittee process, Mr. Hagler.
Thank you, Mr. Chairman. I'm Gould Hagler. I'm with the Independent Insurance Agents of Georgia. For the record, I want the committee to know that I like 8 o'clock meetings. It's those late afternoon meetings in the Judiciary Committee that I find taxing. I have a comment on the amendment, the notice provision of cancellation. I just saw this morning, and I don't know what kind of implications this may have for our members and for their insureds and their relationships with their insureds. Sometimes bills go out from the company. For personal lines, that's the most common way. Sometimes it's agency bill. So I would just like the committee to know and the author to know that our association would like to look at this, and we will. And if we have any later comments or suggestions, we'll discuss it with Senator Schaefer. But I did just want to let the committee know that this is new to us, and we really have not had a chance to consider it. Thank you,
Okay.
Mr. Chairman.
Mr. Golick.
Mr. Chairman, I'd like to move due pass of Senate Bill 385 by substitute LC 286249 ERS.
Okay. Do I hear a second? Okay. All in favor say aye.
Aye.
All opposed, like sign. Okay. Do pass. We got one more bill. Senator, we'll let you do this one.
Thank you. Mr. Chairman.
331.
Thank you, Mr. Chairman. This legislation deals with closing protection letters. Title insurance, as most of you know, is a insurance product that protects the buyer of a piece of property or his or her lender from any defects in the title. Title insurance is issued by title insurance companies who in Georgia operate under monoline authority, which means the only insurance product they can offer is title insurance. A closing protection letter is a document that is issued in virtually every real estate transaction by the title insurance company to the lender, guaranteeing that the funds, that the closing attorney will disperse the funds correctly. Most of you who bought products, who have bought property, have never seen the closing protection letter because it's sent from the title insurance company to the lender, but it's necessary in every real estate transaction. The insurance department has raised the concern that the title protection letter is in and of itself an insurance product. And because because title insurance companies are monoline carriers under Georgia law, they can only issue title insurance. And so what this legislation does is simply clarify that title insurance companies can also issue these closing protection letters. And so it clarifies the existing practice, which hasn't been stopped, because if we were to stop it, all real estate closings in the state would stop. And so we're simply codifying the existing practice, permitting title insurance companies to issue these closing protection letters. And I think there's protection in there to make sure that any charge for these closing protection letters has to be approved by the insurance department. The bill is not a department bill, but it was developed in consultation with the insurance department, and they support it. And I would urge your favorable consideration.
17. All right.
Thank you, Mr. Chairman. Chairman Schaefer, dealing with this letter down on line 53, it talks about the commissioner doing rules and regs to implement this code section. I'm just wondering if you've discussed this with the real estate commissioner and how it would affect the real estate transactions.
I have not discussed it with the real estate commissioner. I've discussed it with representatives of the realtors, of the Association of Realtors, and they're aware of this issue. I mean, I think that, number one, no lender is going to finance a real estate transaction if they don't have some assurance from somebody with money that the closing attorney is going to disperse the money that's received at closing in a proper way. And so these letters have to be issued. And the problem with the title insurance companies issuing them is that the way the code's written, the only insurance product that the title insurance company can issue is a title insurance policy. And so the legislation in front of you simply makes clear that what they're doing now, which is absolutely necessary if we want to be able to buy and sell property with financing, that what they're doing now is lawful.
All right, so this doesn't change how we close a transaction in real estate transactions.
It won't change it at all. It will actually allow us to continue to close transactions lawfully.
All right, thank you.
24.
Thank you. Just a quick question on that same line. Are they currently sort of working outside the law by issuing these letters? Are there premiums involved? Or is this going to will this letter become part of the final issued policy?
It won't be part of the policy because it's sort of guaranteeing against a different risk than the policy protects against. And so that the existing practice what's happening now will continue to happen in exactly the same way, except that there won't be any sort of ambiguity about the title insurance company's authority to issue these letters.
Thank you.
18.
Thank you, Mr. Chairman. Just for Senator, good morning. Just for clarification, sir, will there be an additional cost for these letters, sir?
There could be, but what we said in the bill is that any additional cost would have to be approved by the insurance department.
Okay.
Right now, there's no insurance department approval over the cost of the title insurance policy itself. So the title insurer could charge whatever it wanted for that policy. But on these closing protection letters, if there's a premium for them, that they would have to get that approved by the department, and that was put in there for the protection of the consumer.
Okay. And one additional question, sir. Do you anticipate that cost to be based upon the total cost of the transaction, a percentage of that, or just a flat fee, or just any idea of what that cost could be? I know I'm putting you on the
imagine
spot.
it would be a flat fee. I'm sure they'll try to charge as much as they can. That's normally the way it works, and we'll have to rely on the insurance department to make sure that the cost is not out of line. And I don't, I'm not in this business and don't really understand. My some total knowledge of this business I've just explained to you. But I think I recall them saying that they thought it might be a $35 fee or a $50 fee, something along those lines. Thank you.
Okay, thank you. Any other questions from the committee? Okay. I guess it's time for a motion of some sort.
I move to pass, Mr. Chairman.
Okay, do pass. Second. All in favor say aye. All opposed, like sign. Thank you, sir.
Thank you, Mr. Chairman.
Be sure to take your stuff to rules.